case. I think it's
Yeah, I'm not going to use that one. I found it. You're right.
okay. Is the wrong case?
Short opening. Sir, you can stay at council table wherever you're comfortable. Judge, it's our position that based on the fairly debatable legal issues we intend to raise on appeal and an application of the Youngins factors, that a bond pending appeal is appropriate in this case, and we're going to present the testimony of 4 witnesses to help establish the Youngins factors. I would note that this was a close case where the jury found Ms. Benefield guilty of a lesser included offense. At some point during their deliberations, they were hung and came back to the court and advised the court of that. And I think they had at least one or more questions for the court. So again, it's our position this is a close case, and that under the circumstances, based mostly on Ms. Benefield's history and characteristics as a person, as well as her strong support from family and community, that she should be granted a bond. Thank you, sir. State, did you want to make an opening?
No, other than I think the court knows the state's position that we would oppose bond.
Okay. All right, Mr. Fennell.
The defense calls Janelle Peasmeyer.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Morning, ma'am. That microphone adjust up, down, left, right if you needed to.
Thank you.
Good morning.
Good morning.
Could you state your full name?
Sure. Janelle Kuzmeyer.
And how are you employed?
I am a supervised release officer with Manatee County Probation.
How long have you been doing that?
I'm coming up on 10 years.
And do you know the defendant in this case?
I do.
How do you know her?
I was her supervised release officer for 4 years.
How long was Ashley, Miss Benefield, out on bond?
She was out on bond for 4 years with me.
And did you monitor her that entire period?
I did.
Was Ms. Benefield on GPS monitoring when she was released?
The whole time, yes.
Did she ever violate any terms of her monitoring?
She did not.
Did she ever violate any other terms of her release?
She did not.
Did she abide by the terms of her curfew?
Yes, she did.
And did you have any issues with Ms. Benefield otherwise?
I did not.
Did she keep in contact with you?
She did, yes.
Was she honest with you?
I'm sorry?
Was she honest with you?
As far as I know, yes.
Did Ms. Benefield maintain employment while she was out on bond?
She worked for several different employers, but I don't know if it was consistently through the 4 years, but she did have several different jobs.
Were there times during your monitoring period that the court granted Ms. Benefield permission to travel outside of the jurisdiction?
Yes, one time out of state and at least, I believe, 2 times to Orlando.
Did she keep you advised of the details of that travel, including dates, times, of when she was leaving and returning and where she would be staying?
Yes, she was very good about communicating those things.
Do you have any reason to believe that Ms. Benefield would be a flight risk if released on bond pending appeal?
Based on my 4 years with her, I don't have anything that jumps to me thinking that she would flee. No.
Thank you. No further questions.
Cross.
No question.
Can the witness be excused?
Yes.
State.
Yes.
All right, ma'am, you're excused. Thank you very much.
Thank you.
All right, your next witness.
The defense calls Dr. Barbara Russell. In the meantime, we'll call Laura Zito.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Morning, ma'am. And that does adjust if you need to move it up, down, left, or right.
Okay, thank you.
Good morning.
Good morning.
Please state your name.
Laura Zito
Where do you live?
in Manatee County
How long have you been living in Manatee County?
for 8 years.
What do you do for a living?
I'm a stay-at-home mom.
And how long have you been a stay-at-home mom?
7 years.
How many children do you have?
5.
Oh, wow, 5. Do you know the defendant in this case, Ashley Benefield?
I do.
How long have you known her?
For just over 9 years.
Did you and Ashley spend time together with anyone else? Any other friends in your group?
My husband.
How about other young mothers?
Throughout all the years, it was pretty much us two.
Okay.
Yeah. There are a couple times where we had other people around at gatherings and stuff, but we would hang out together.
Okay. Could you describe for the court who Ashley is as a person?
She is a very genuine, honest, loving, giving, very gentle person.
And have you had the opportunity to observe Ashley as a mother to her daughter?
Yes.
Could you describe how she is with her daughter?
She's very loving, very patient and kind. She's attentive. She's helpful in every way, just always ready to do anything for her.
And have you continued to support Ms. Benefield since the incident in this case?
Yes.
And if she's released on an appellate bond, would you continue to support her?
Yes.
Do you have any reason to believe that Ms. Benefield would be a flight risk?
No.
Thank you. No further questions.
Cross? Hold on, ma'am.
Sorry.
It's all right.
No cross.
All right. Now you're all set.
Thank you. The defense calls Jana Martin.
Stand right here, please, face the clerk, raise your right hand and be sworn in.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
This way, please.
Good morning, Judge White.
Good morning, ma'am. As you sit down and make yourself comfortable,
Yes,
that microphone adjusts up, down, left, right, however you need it.
thank you.
Good morning.
Good morning,
Could you state your name for the record?
Jana Taylor Martin.
Where do you live?
I live at 2510 Loma Linda Street, Sarasota, Florida.
And how long have you lived in the Sarasota area?
Almost 40 years.
What do you do for a living?
Well, right now I am a missionary and a Bible teacher and a chaplain. But I started out as an elementary school teacher and I sold real estate 40 years.
And do you know Ashley Benefield?
Yes, I do.
How did you meet her?
I met Ashley in 2016 when I was called to do a prayer initiative for President Trump, and she was the coordinator between President Trump and the women that prayed and interceded for him.
And is it your understanding that Ms. Benefield lived in the Bradenton or Sarasota area since 2016?
Yes, she did. She lived first with Barbara Russell, and then after approval, she moved into our guest house, 15 steps from my back door.
And in the time that you've known Ms. Benefield, did she have family and friends in the Manatee County area?
She did.
And did you and Ms. Benefield participate in any church groups?
She was in my Bible study. Even her little Emerson, that's 7 now, and her mother, Mimi. So yes, she did, and I have been walking with Ashley for 9 years almost.
How often did your Bible study meet?
A weekly.
How many people participated?
It's all women, and it would vary anywhere from 8 to 14, except one time a man came. One man. That was all. And it was just pretty much focused on the Bible and the way to walk with the Lord.
And you mentioned that it was mostly women. Were they women of all ages, from young women to senior citizens?
Yes, they were all ages, and they were from different churches and different walks of life.
And to your knowledge, is Ms. Benefield close friends with any of these people that she met at the Bible study?
Some of them are sitting right there in the courtroom, so the answer is yes.
And do the members of the Bible study, do they continue to support Ms. Benefield?
Yes, not only with love, but they've helped financially also. They've stood with her 100%.
And you mentioned that Ms. Benefield lived with you at some point in your guest house?
Yes, she did.
When did that start, and how many years?
After this happened, after the incident, she was with Barbara Russell. She wasn't allowed to come be with her daughter in Emerson until it was approved by the powers that be. And then they came to our guest house, and we prepared it properly, and we met all the regulations for it. And my husband, which I just lost, it was never any cost. We're blessed to be a blessing. We loved having them there. It was a great gift for us to have them. Yeah.
I'm sorry for your loss.
Yeah, me too. He was great.
And you kind of mentioned it. Did you charge Ms. Benefield rent?
Never. Not one dime. I didn't want it. We wanted her to be there and be safe, and we believe she was.
And at the time that she was living in your guest house, was she working?
She was. Different jobs at different times, and always obedient. I remember, I have to be here at this time. It was always, she was very obedient about being on time and right. And yes, she did have different jobs.
And could you describe for the court who Ashley is as a person?
She's precious. I've never heard the child say a curse word. She's mature beyond her age, and she had a position with Mr. Trump, whether you liked him or not, that she did a great job. She was obedient. She had a good position. She led the prayer team, and we prayed for months for Donald Trump before he won. She is a lovely, smart, outstanding, godly girl. Is that enough?
Yes, that is enough. Thank you. And did you have the opportunity to observe Ashley as a mother?
Impeccable mother. As a child, I would go to the guest house and she'd be holding Emerson. They'd be talking about dinosaurs. They'd have books. They'd be watching shows. She was an impeccable mother. She put her first. She had her in a ballet. She had her in swimming. She had her in tap. She did everything she could to support Emerson, and still is. And I wish she could be with Emerson and supporting her now.
How old is Emerson?
7.
And to your knowledge, did Emerson participate in any programs or activities in the local area?
Absolutely. The Nutcracker with the Sarasota Ballet.
Anything else?
If I may, at my husband's funeral last week, they asked for people to speak. Emerson came up the aisle in her cowboy boots, and she took the microphone, and she turned around and she said, "I love my Papa Jim, and I understand because my cat died." It's a precious child. She's missing her mother desperately. But I had a smart son. She's bright. She's very, very bright.
Thank you, Ms.
It's just, I know, I may be saying too
No,
much.
that's okay. I didn't mean to interrupt. If Ms. Benefield is granted an appellate bond, where would she live?
She would live 10 steps from my back door.
Is that in the guest house or somewhere else?
Actually, it's in another house we own next door that's bigger. and more room where I think they could be a little more comfortable. The guest house isn't that big.
And would she be living there with anyone else?
Yes,
Would it be
her mother and Emerson. And it would be no charge.
And how are they already living there? Her mother and Emerson.
They are.
Do you know how long they've been there?
Yes. Whenever Mr. Neal, I mean, it was around Thanksgiving. Don't hold me to that.
So
But
a couple months.
yeah.
And if the court were to impose conditions of release such as an ankle monitor or curfew, would you help her in complying with those conditions?
Absolutely. 100%.
Do you have any reason to believe that Ms. Benefield poses a flight risk?
Never. Absolutely never. Absolutely never. I believe with all my heart, she would be obedient. She was obedient the last time. I think she would be obedient again.
Just one moment. And would you be willing to be sort of like a custodian for Ms. Benefield? If you notice any violations, would you report them?
Yes, and I'd be a good custodian because I tell the truth, and I would be obedient as a custodian, and it would be my honor. If the judge's heart would see it, it would be an honor for me to be a custodian at this time. That's going to be hard for me to be alone with. I'd love to be a custodian.
And since Ms. Benefield's arrest, have you been providing her with emotional support?
Yeah,
Will you continue to do so?
absolutely. With prayer, with guidance, and we're going to walk this out, and the Lord rules.
Thank you. No further questions.
Thank you, Judge.
Hold on 1 second. Cross?
No question.
Okay,
Thank
now
you.
you're all set.
Thank you, Judge.
Thank you, Ms. Martin. If it would be possible, if we could try to see if Dr. Barbara Russell is out there now. She is? Okay.
Stand here, please. Raise your right hand and swear.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
God, I do.
Good morning, ma'am.
Good morning, Your Honor.
Just adjust the microphone however you need.
Okay.
Good morning.
Good morning.
You could please state your name for the record.
Barbara J. Russell.
And what do you do for a living?
I have a mental health practice. I do clinical and forensic evaluations and counseling.
How long have you been doing that?
I'm here in Florida for about 15 years.
Do you know Ashley Benefield?
I do.
When did you meet her?
I met her in the spring of 2020.
What were the circumstances of that?
She came to my office seeking an evaluation.
And how long have you had a professional relationship with Ms. Benefield?
Pretty much ever since then.
And did you continue to communicate with her after the shooting incident in this case?
Yes.
Did Ms. Benefield live with you at some point?
Yes.
Do you recall when about that was?
Late October of 2020.
And how long did she live with you?
Approximately 8 months until her DCF case was resolved.
And why did you allow her to live with you?
Because I don't think I ever could have held my head up high or looked my kids in the face if I didn't. She was severely traumatized after the shooting incident and everything that had happened prior to that. And because of the DCF involvement, she was not allowed to live with her mother and daughter, and she was effectively homeless. The financial abuse in her marriage had robbed her of all financial resources. And I could not abandon a client and say to her, well, good luck sleeping in your car. I hope you get your kid back. It was out of the question.
Did you charge her rent?
No.
Is it fair to say you were trying to help her through a difficult situation to the best of your ability?
Yeah, I had an obligation not to abandon her and to make sure that she was safe and that her daughter's mother continued to be safe.
And to your knowledge, how long has Ms. Benefield lived in the Bradenton, Sarasota area?
I believe she moved here, it was like 2012, 2013. She danced for the Sarasota Ballet. She continued to live here after her retirement from the ballet. She did live in South Carolina for a couple of years in the early part of her marriage to Douglas Benefield, and then returned to the Sarasota-Bradenton area afterwards.
To your knowledge, does she have any ties to the local community?
Oh yeah, she has many ties in the local community.
How about a church community?
She has a church community. She participates in various Bible studies, and she attends a Torah club as well.
What is a Torah club?
It's like another Bible study. It's a weekly gathering and studying of Torah, and she has friends and fellowship in that group as well.
Are you aware of Ms. Benefield participating in any pro bono work?
Yes, she was working for Elite Teams Ministries, doing a variety of things, some youth mentoring as well as social media marketing.
And could you describe for the court who Ashley is as a person?
Ashley is a very loving mother. Ashley is kind. Ashley is compassionate. She's a good moral compass. She's just an all-around great girl.
You mentioned that she's a wonderful mother. To your knowledge, is her daughter involved in any extracurricular activities in the Manatee County area?
Oh yeah, she's been in the ballet for several years. She's participated in swimming lessons and is involved in different, social activities. She has a lot of little friends.
And have you had the chance to observe the impact of Ms. Benefield's absence on Emerson?
Yes, I've seen Emerson a couple of times since her mother's incarceration. She misses her mom. She just wants her mommy to be with her.
And have you assisted Ms. Benefield in getting a job if she is released on bond?
Yes, she has a job waiting for her.
And what is that?
She would be working at Bishop's Aluminum. It's a corporation in Sarasota. They make the aluminum parts for pool cages.
Do you know what her role would be in that?
It would be physical labor. She would be starting out like in the factory doing prefabrication work, and she can move up to assembly.
And since the incident in this case, have you provided emotional support to Ms. Benefield?
Yes,
Will you continue to do so if she's released on bond?
of course.
Do you have any reason to believe that she would flee if released on bond?
No, that's the last thing she would do. She would never abandon her daughter, and Ashley would follow the rules. She would do everything the court told her to do. She is a rule follower. She's always been very structured, methodical. She follows rules. She does things the way they're supposed to be done.
No further questions from the defense.
Cross?
No.
All right, thank you, ma'am.
Thank you, sir.
Judge, we don't have any other witnesses. We have, with the court's permission, there's several people in the audience here in support of Ms. Benefield who are also willing to act as custodians if the court were to grant a bond and to report any violations they became aware of. We've explained to them that if they were assigned that role and failed to do so, they could be held in contempt. So with the court's permission, I'd simply like them to stand up and state their name for the record.
Okay.
Anyone who's here that is willing to act as a custodian for Ms. Benefield, as we explained, please state your name for the record, starting with here.
Pamela Hagan. Jane Berge. Susan Byrne. Laura Zito. Michael Zito. Jana Martin. Louis Stevens.
There's one more.
Thank you. We don't have any other evidence or testimony, just legal argument.
All right. State, any evidence, witness, or testimony?
Judge, I don't have any evidence. I do have a member of the family that would like to speak.
Okay.
Mr. Tommy Benefield. Yes, yes.
All right. Go ahead.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
It is, yes.
And this is a statement pursuant to Marcy's Law?
Yes.
Okay.
It is.
Thank you, Your Honor, for hearing from the family today. As has been spoken in court today, it has been over 4 years since the defendant or the convict killed Doug Benefield in a single shot killing that has been a conviction of manslaughter with a firearm. There are two sides to Ashley Benefield that have been portrayed throughout my longtime association through Doug to Ashley, through all of his business friends and partners who got to see Ashley from the very beginning of the relationship. There are believers, they're in this room and they're elsewhere, and there are people who saw through the actress that we have seen over time. Of that 1,597 days since the killing, she's been out of jail. She was fortunate enough to be allowed out during the COVID time, which allowed her to be on an ankle bracelet and with their daughter from basically 3.5 years old to she'll turn 7 in March. Most of that time, it's almost 90% of the time since the killing, she's been out of jail. She was fortunate enough to get that time. It's clear that the believers, from our point of view, have supported her with money this whole time. But the part of the story that's not told, and I have access to every bank record our family does, even the week before the killing, Doug had to borrow $25,000 to support the move of Ashley, Alicia, and Emerson to Maryland. And it was just a few days before that he needed the money to even move the family, I'll call it, up to Maryland. So for him to be portrayed as not supporting her is just a lie. We have the bank records, we have the money transfers. So many things in this portrayal today is one side of what she can present. But the reality of Doug paying for her counseling, their marital counseling, providing money, paying for clothes purchases, predominantly paying for almost everything that Emerson required up until the time he was killed. The other part of the portrayal today that Doug did not support her and left her destitute, or not that word, but close enough, is that the supporters have made that happen for her. However, the financial support and the jobs that are talked about, I'd love to know, and the family would love to know, the very few times that she worked during that period. And if we remember back to the first case, especially in court testimony, she was allowed to get out with a job, supposedly with her attorney previous to this case and the child custody and divorce case. That job didn't last. There are witnesses from her work period while she was out on bond previously that have a very different story to tell of who Ashley Benefield is. Since the sentencing and her not getting out, they have come forward. So there's a very different picture of
Object to, based on hearsay, now we're talking about what someone else has told him.
It's a Marcy's Law statement.
I want to object to the record and ask the court to make a ruling, please. I respect.
This is not evidentiary. This is not evidentiary.
I understand, and I respect the ruling. For the record, I'd like a ruling.
Overruled.
Thank you, sir. From the first night that I spent the night in Ashley's mother's home, I believe in the room where Doug was killed. The next morning, I told Doug at coffee I would not stay in the house anymore due to the evil in the house that was not presented, but how I felt about being there. And I went to a hotel that night and stayed. So I've been around Ashley for many years personally. There are other people who, matter of fact, Trip Cormany, who married them. I know for a fact that she can present two ways, and she has throughout this case. And if you believe her, then this is a case of that. She's had the financial support to get through all of these trials and all this time, all of these attorneys, without her paying for them. So I do believe, and the family believes, that she has the ability, especially now that she's been sentenced to the 20 years and 10 years, and she's had financial support all along, that would be very simple for her to avoid this prison time by having supporters provide money for whatever they say it's going to, and it's very simple to get out of the United States and disappear. We believe as a family, as the supporters of Doug, that she's not the same person now, nor would she necessarily behave the same way as she did in her first bond period for 1,300 days. We do not believe at any point. The last part of what the family, and I'll call it family, is that there is family of hers that would not come forward to speak with us and tell us the truth about how threatened they felt. Direct family of Ashley's, who has now become friends and family of ours, who would not come forward until the sentencing was done for fear of how she would do retribution on them. So her own real family, outside of the people of Emerson and Alicia, but other members of her direct family, don't believe she will stay, and she will stay during the bond for the appeal to be answered. They can't be here today. They still feel that it would be dangerous for them to speak in person. But as a family, we don't believe that she will stay through any bond that she has. She's been out 90% of the time since the killing, and we believe that she's had the benefit of all that time with their daughter from 3.5 to almost 7. It won't hurt to keep her in jail. She should be kept in jail during this period. Thank you, Your Honor.
Thank you, sir. Any other statements?
Judge, I believe that's it.
All right, and no evidence?
No evidence, I just have an argument.
All right. I'll consider the evidentiary portion of the case closed, or the hearing closed, and I'm prepared to hear argument. Thank you, Judge.
Judge, I'll start by saying I certainly feel horrible for Mr. Benefield's loss, but I'd ask the court not to consider the speculation and the hearsay testimony about family members that are not coming forward and individuals that are making statements that can't be substantiated. As it's our position under Rule 3.691 and the Youngins case that Ms. Benefield is entitled to a bond pending appeal. As the court is aware, under the rule and the case law, the defendant is normally, and this is from the Baker case that I provided to the court, it says a convicted defendant should normally be admitted to a bail pending appeal if the appeal is taken in good faith on grounds not frivolous but fairly debatable. So it's normally, this isn't an exception, this isn't a rare occurrence, it's the normal course of business unless there's factors that suggest it's not appropriate. And the good faith requirement for purposes of appeal is simply to raise claims that are non-frivolous on appeal that are fairly debatable. I think ad nauseum the issues that are going to be raised on appeal have been addressed to the court. I think the court would be hard-pressed to find that we don't have any fairly debatable issues. I'm not going to go through all of them. I will just point out that I believe there's a fairly debatable argument that the state's closing argument misrepresented evidence. There's a fairly debatable argument that Juror 15 committed juror misconduct that justified a new trial. There was a significant number of rulings by the court prohibiting introduction of evidence that would have supported Ms. Benefield's defense. We think we have a legitimate argument that the state did not meet their burden of proving beyond a reasonable doubt that Ms. Benefield was not acting in self-defense. So there's a variety of issues that I think meet the very low threshold of fairly debatable, and I'd be surprised if the state disagreed that we meet that standard. Once we meet that standard, we move to the Youngins factors, and there's 4 of those, and the first is the habits of the defendant as to respect for the law. As the court knows from the sentencing hearing, from the PSI, this is Ms. Benefield's first criminal incident. So she has a long life of not being involved in any criminal activity. And we also know from her pretrial services officer that she was a 100% obedient person on pretrial detainee with no issues following the requirements of electronic monitoring, following the requirements of her curfew, following all the requirements established by the court. So it's our position that under the case law, the habits of the defendant as we respect for the law weigh heavily in favor of Ms. Benefield being granted a bond. I don't think there's any evidence to contradict that in any way. The second issue is her local attachments to the community by way of family ties, business, or investments. We've heard testimony from today, and the PSI notes that both Ms. Benefield's mother and daughter live in Sarasota, and that Ms. Benefield has lived in the Sarasota-Bradenton area since at least 2016. She has a home that is being given to her to live in by one of her friends, a longtime friend who testified here today. We also have the testimony of Barbara Russell, who was willing to give Ms. Benefield a place to live when she was in a time of need. It's hard for me to imagine a stronger showing of support than providing an individual that doesn't have a place to live at no cost. We have a letter from Reverend Brown indicating that she's strongly involved in the community, in prayer groups, in the Torah Club. We have other testimony about her involvement. It's clear that she is tied to this community by family, friends, and work. We have a letter indicating that she has a job waiting for her, and she's ready and willing to start that job to support herself and her daughter when she's released. The third factor is the severity of the punishment imposed, and I would certainly be disingenuous if I argued with the court that a 20-year sentence is not a lengthy period of time. But the Cooley case from the 2nd DCA, 1998, gives a pretty good discussion of how to weigh the sentencing, the sentence. And in that case, they talked, the trial judge denied bond because Cooley was facing a minimum mandatory sentence. And what the 2nd DCA said is they have the authority, the legislator has the authority to exclude certain crimes or certain conditions from when people could be granted a bond. So if they wanted to, they could say anyone that was sentenced to more than 10 years or anyone that was sentenced to a crime with a firearm is precluded from being granted a bond. As the court is aware in its earlier order on the bond issue, there is actually a statute that lists crimes that you cannot get a bond for. Manslaughter with a firearm is not one of those crimes. So although the 20-year sentence, I would say, does not mitigate in favor of Ms. Benefield, I think the case law, including the Cooley case, indicates that that factor alone is not sufficient to justify a bond. Same issue is addressed by the 4th DCA in the Baptiste case.
Baptiste?
Yes, Baptiste, 4th DCA, 2012. They cite back to Cooley and again say the length of the defendant's sentence is not by itself evidence of flight, and that's the purpose of bond, is to prevent flight. The fourth factor is any evidence that Ms. Benefield would be tempted to remove herself from the jurisdiction of the court, and I suggest there's no evidence of that. In fact, we have the contrary. We have 4 years of strict compliance with the rules. We have years and years of compliance with the laws of the United States and Florida. We have numerous individuals in this courtroom willing to act as custodians and to report any violations. All we have is speculation that potentially someone with a 20-year sentence would be tempted to flee. But again, the case law makes it clear that that fact alone, just the sentence, it has to be tied to a specific fact or something else. You need something else besides the sentence to support the denial of a bond. And with the strong support exhibited here today, it's my position that Ms. Benefield, there's no evidence she's likely to flee, and everything she's done up to this point is consistent with her attempting to exonerate herself based on self-defense, and she continues to want to do that through the appellate process and through whatever means she can. There's simply no evidence that she would leave the jurisdiction in this case. Finally, I point the court to the Dooley case from Hillsborough County. It's a similar circumstances as this. Mr. Dooley, and I met Mr. Dooley, so I have personal knowledge of the case. Mr. Dooley was convicted of manslaughter with a firearm based on an incident which he claimed self-defense. And he was sentenced to 8 years in prison at the age of 72. And two different judges, then Judge Ashley Moody and then Judge Barber, granted bonds pending appeal based on the fairly debatable issues and his history of complying with the conditions of his release. It's our position that the circumstances of this case are similar to those in Mr. Dooley's case. And the Dooley case is an example of why an appeal bond exists. The purpose of the appeal bond is twofold. One, if a person has a good faith appeal and they win it, they really don't deserve to serve the time if the appeal is won. And secondly, it's to ensure that they don't flee the jurisdiction. So it's our position that the Dooley case, again, is similar to Ms. Benefield's, and we'd ask, and in that case, they imposed a bond of $100,000 and various conditions, including travel conditions and GPS. We recognize that the bond in this case was $100,000 prior to trial. We recognize that the circumstances are different after trial, and the case law says that it makes some sense for the bond to be a little bit higher following a conviction, because the concerns are different. So we'd ask the court to impose a bond of $150,000 with the same conditions that were imposed pre-trial. To remind the court, Ms. Benefield had previously surrendered her passport. She's perfectly willing and able to submit to GPS monitoring and to have a curfew as she did before. And finally, I'll note that there was at least 2 occasions where the state agreed to Ms. Benefield to travel, once to Orlando and once out of state, where she traveled through various states and went to Maryland and Washington, D.C., and those 2 orders have been entered into evidence. So even the state prior to trial was not concerned about Ms. Benefield fleeing the jurisdiction, and at that point she was facing a charge of second-degree murder with a firearm where she could get up to life in prison. So any incentive she had to flee existed then as well, and she remained dedicated to proving her innocence and proving her claim of self-defense, and she remains in that same position today. So we'd ask the court to grant the bond pursuant to those terms.
Thank you, sir. State.
Judge, first I'd like to address the Dooley case that defense brought up, and also to state for the record that I have read all the case law that the defense provided, and I've read through this Dooley paperwork that was provided. I disagree that it's exactly like this case. The Dooley case couldn't be further from the truth. Mr. Dooley was like 72 years old. He shot a stranger in his own home. He was given a supersedious bond and turned himself in when he lost his appeal. And then when it went back, where it was going to all start over, they gave him a bond again. So he had already demonstrated after the sentence that he could come back and turn himself in after the appeal. He lost the appeal. So I don't think Dooley is at all analogous to this case. Also, I don't think any of the cases that defense cited, while some of the factors may be similar, I don't think that they are analogous because these things are so fact specific. And most of the cases that the defense cited, the court did not rule with enough specificity. or with enough facts. And the appellate courts found their orders to be lacking. So the vast majority of the reasons that these cases were overturned was because the proper factual findings were not made by the court. And that's individual to each case. So the case law says that a denial by the court must be based on record evidence, which the court's been here from the beginning, been to all the hearings, been to the stand your ground, been through the trial. You've gotten a plethora of record evidence that you can draw from. And also the court can consider any reasonable inferences from that evidence or that record evidence. The question is, what are the factors that distinguish this defendant from other defendants that maybe are charged and convicted with manslaughter or manslaughter with a firearm? What is the difference? And that's what I want to concentrate on, because that is the factor of the severity of the sentence and the specific factors of this case. I would agree, the state is not making an argument about the frivolous appeal issue. The state is not making an argument that she does not have ties to the community. There are issues with the fact that while she was out before, she never had consistent work, and she always relied on other people to fund her, and she is still relying on other people to fund her. However, but the state's main argument is going to be about the length of the sentence and the specific factors of this case that should tell the court that she is likely not going to show up after she loses an appeal. This case is manslaughter with a firearm. It was not a knee-jerk decision. It was not kids playing in the back of a car with a firearm that accidentally goes off. It was not a homeowner that shoots the pool guy because he thinks he's an intruder. It was not a DUI manslaughter where someone is drunk and accidentally hits someone. This case is very, very different from all of those other manslaughter with a firearm cases. This case is unique. This was the culmination of a 3-year campaign that started when she got pregnant. And the campaign started then, and she kept with that campaign all the way through the day that she killed Doug Benefield. And she not only stuck with that campaign, but she adjusted, and she changed, and she adapted to the things that were thrown her way. She started, for instance, with an injunction in South Carolina. When that didn't work, she tried to get an injunction here in Florida. When that didn't work with allegations of violence against her, then she started saying there was violence against the child. And when that didn't work, then it was sexual abuse against the child. She adapted her behavior every time the system told her no. This is a very calculated set of behaviors by the defendant. When all other options failed, she shot Doug Benefield to achieve her goal. And we all know the goal was to have sole custody of her child. And I've heard a lot of people today say that Ashley's honest and truthful, but I've also heard, and I think the court's also seen, that there are different sides to the defendant. And I think the court can consider the fact that a different judge, Judge Moreland, in her order before, specifically found that she was not credible. She was dishonest with the court and was not telling the truth. So if the court is to believe these friends of the defendant, the court can also take into consideration that another judge found her to be completely dishonest and not credible. This trial was her last attempt to keep her child. She'd already achieved the goal. She'd gotten rid of Doug. So this trial was her last step. And to be honest with you, I don't think she had an inkling that this court was not going to, or that this jury was not going to believe her. I don't think in a million years she thought she was not going to be able to convince this jury. But she didn't. And after the trial, they told her they did not believe her. Her version of events was not credible. And this absolutely was not self-defense. So when you talk about how she complied with pretrial services and all that before trial, you have to look at it through that lens. She thought she was going to convince this jury, so she complied. She did everything she was supposed to do. She showed up to every court hearing she was supposed to come up to. She kept her ankle monitor on. She did all of that because her end goal was to put her case in front of a jury and win, and everything would be fine. Now Doug's out of the way, and now she has her child. That's the difference in this case, because now her last-ditch effort has failed. And the jury has told her no, and she has now been sentenced to 20 years. Her incentive to comply with pretrial services, with bond, has been removed, completely removed. So the court cannot consider the severity of the sentence alone. I would agree that the case law says you cannot say, well, it's a 20-year sentence, so therefore she might flee. But you are absolutely allowed to consider that sentence in conjunction with the facts of this case. So let's look at the facts of the case. 20-year sentence, the earliest she could be released, roughly, my calculations are correct, with good behavior is after 17 years. So that would be in the year 2041. Her daughter is 6. Her daughter would be an adult by the time she got out. Her daughter would be 23 years old. And her entire goal throughout this entire case for years and years and years and still today is to be with her daughter. And she knows that if she loses this appeal, she has to turn herself in. She was willing to kill a human being to meet this goal. There is nothing to prevent her, if an appeal comes back not in her favor, from deciding she's not going to present herself. It's actually based on her prior behavior and the prior motivation and the prior calculation. It's actually pretty likely that she would then absent herself from the jurisdiction and from the court to not serve her 20-year sentence. And that is what is different about this case and specific to this case and the reason that this defendant should not get a bond. Thank you.
Thank you. Yes, sir, rebuttal. Before you start, earlier you had talked about the Dooley case in Hillsborough.
Yes.
I thought you had talked about another case from the 2nd DCA, but I now see in your packet there's a Cooley. So I think I misunderstood. At one point you were talking about Dooley, and another one you were talking about Cooley.
Cooley is a case from the 2nd DCA where the defendant was convicted of second-degree murder with a firearm and was denied an appeal bond by the trial judge. The 2nd DCA reversed that, and despite the state's argument to the contrary, it wasn't simply because the order wasn't sufficient. It was because the judge improperly considered on its own the length of the sentence as a basis to deny the bond. That's why we rely on Cooley, because it's not appropriate under the Youngins test to use that factor alone to deny bond.
I understand. I just want to clarify the
Yes.
record that there's been references to a Dooley, which is 2 trial court orders, and Cooley, which is a 2nd DCA thing. All right.
And as far as the state's effort to distinguish Dooley, I want the court to be clear. There was 2 bond orders granting appeal, so although the state's correct that the second time they've already shown that Mr. Dooley could be out on appeal, and it's a unique case because he lost his direct appeal, then I was retained and filed, and he was out on appeal bond while that appeal was pending. I didn't represent him on that appeal. Then I filed an ineffective assistance of appellate counsel under Rule 9141, and they granted us a new appeal. At that time, a second appeal bond was granted. But at the time of the first appeal bond that was granted by Judge Ashley Moody at the time, Mr. Dooley stood in the exact same position that Ms. Benefield stands in here today. It was after a trial where he claimed self-defense, and he was found guilty of manslaughter, and was sentenced, and immediately after the sentencing, the judge granted an appeal bond. So the procedural posture is identical, other than the fact that 2 different judges thought it was appropriate to grant Mr. Dooley an appeal bond. The state spends a long, and I want to note that Ms. Benefield voluntarily surrendered herself the same day the warrant was issued in this case. I'm sure that's reflected in the court file. So there's no difference in her behavior compared to Mr. Dooley's behavior. The state makes a lot of argument about the specific facts of this case. And if you look at the Torpilez case, 2024, 3rd DCA, they talk about the nature of the crime and the circumstances of the instant offense and say that you really shouldn't consider the nature of the crime because it says, quote, if the nature of the crime alone were sufficient to deny bond, it would render the fact-finding and application of the Youngins factors irrelevant. State spends a long time talking about this detailed plan, and if you believe the state, this sounds like a first-degree murder case. You know what? The jury didn't find a first-degree murder. Ms. Benefield wasn't charged with first-degree murder. She was charged with second-degree murder. The jury rejected that. They did not find depraved mind or malice. They found manslaughter. So, the state has a theory and speculates that this was a long plan and this was somehow premeditated. We're not allowed to second-guess the jury's verdict. We accept the jury's verdict, and the court needs to rule based on the jury's verdict. It's not the state's opinion that there was a long plan. The jury's verdict is a manslaughter on that date. They have made no findings of fact concerning planning, premeditation, depraved mind. In fact, they rejected depraved mind and malice. This idea that she's been financed by other people, I didn't hear any evidence of that. I'm not aware of any evidence in the record of that. The state cites to, quote, record evidence. I'm not aware of a single piece of record evidence that supports the idea that she's going to flee, other than some speculation by the state that her last-ditch effort was to convince the jury, and she thought she was going to win at trial. I have a difficult time with that. I think most defendants that go to trial expect to win. That's why they're going to trial. So that's not unique to Ms. Benefield. It's not unique that she claims she's innocent. Thousands of trials happen in this courthouse where people go to trial and claim they're innocent. Some were acquitted, some were found guilty as charged, some were found guilty of lesser included offenses. The idea that she went to trial and thought, quote, she could convince the jury she acted in self-defense, number one, that's her right. Number two, again, it's not unique to Ms. Benefield. So I don't agree with the state that that's a legitimate basis to deny bond pending appeal. She has an extraordinary level of support in this community. She has strong issues for appeal. She has a long history of complying with the conditions of release. There's just simply no evidence in the record that she's going to flee except some speculation from the state. So I'd ask the court to grant the bond.
All right. Thank you all very much. I'll take it under advisement and issue a written order.
Thank you, Judge.
Thank you.